Friends, continuing with our understanding of the basic principles and foundation of contract law, uh, let's also now, at this point of time, evaluate whether contract law can apply to a student-university relationship. Now, we know that university in India have been in the sector of providing education, and we can divide education into either primary, secondary, or higher education. But we are not talking of any of the elementary education. We are talking of university education, which of course is education that is provided to adults, and it is something that is of a sector that is governed by the University Grants Commission. Now friends, why are we even testing this under contract law? For the simple reason is, friends, today you will notice that during say pre-LPG era, that's liberalization, privatization and globalization, that is pre-1991, education in India was solely provided by the state, that is government. We had only state universities that were established, and those were the only forms of providing education. But we looked at privatization of education, and today you will notice that there are a lot of private universities that are providing education, and hence students may have grievances, students may have problems. What law will actually govern that kind of a problem or relationship? Right? This is the kind of evaluation that we must always look into. Now we know that apart from the premises of the Constitution, where we talk about education as a public service, as a public good, we are talking about how the Supreme Court from time to time talked about whether capitation fee can be demanded by institutions, whether there can be a management seat, what should be the modernization of education, and what is required in terms of the cost of education. I think the Supreme Court has been called upon to adjudicate some of these matters. But in most cases, the party to such litigations were actually public institutions or public aided institutions. Now, aid to a private institution also makes that university have some kind of public character. Now, aided institutions, you would notice, are covered under the writ jurisdiction because they have substantially got aid from the government, and that aid could be for the salaries of the teacher, it could be developmental grants that the UGC provides, and hence even those privately managed but publicly aided institutions got covered under the constitutional mandate, and hence the writ jurisdiction could be brought about to hold these universities accountable. But then coming to the completely unaided institutions, which are pure hardcore private institutions, that is where probably the apart from constitutional law, if there is any other law for evaluation, it has to be tort law. The law of tort is called the law of civil wrong, and you will notice that in tort law we talk about educational malpractice, right? Educational malpractice is a kind of deficient service of an educational institution due to the negligence to which the student has suffered some kind of an injury of, say, the learning experience or learning assessment, and hence the student may actually sue the university for the tort of educational malpractice. Now, this is a tort that has been established to some of the judgments in both UK and in the US. So that is also one of the premises that students have to actually adjudicate and redress their grievances as well. However, why should we even talk about contract law? The reason being simply, friends, to start off with, the simplest reason we can look up to is the United Kingdom. Friends, if you look at the United Kingdom, the UK universities have actually resolved and said, we want to govern the student-university relationship under contract law. It's a choice that has been taken by the universities, and it's a uniform choice taken by all universities. Now, they say that contract law is good, and it is a statute, unlike tort law, which is more judgment law. In contract law, you can actually put the terms and conditions explicitly, communicate the same, you can get an agreement, you can take the consent, and things can be far more clear rather than leaving it to the discretion of the judges under tort law. And hence, universities in the UK have very clearly said that if students get admitted, they are bound by contract law, and any such issue of disputes between the student and the university can result in a breach of contract. Now in India, you will notice that there are a lot of educational institutions which are, say, coaching institutes. There is coaching for medical examination, coaching for law examination, coaching for engineering examination. And hence deficiency of service is something that is a major problem in terms of whether what has been promised by the coaching institute has been delivered or not. Now in India, students who have gone to these private tutorials or coaching institutes, or say online coaching institutes, it could be an online institute like a Byju's or Akash or any other, they all provide some kind of learning and educational services. Probably you will notice that the law in India on consumer protection is also an additional law that students can actually use. And you will notice that you would have hired the service of this coaching or tutorial services, be it offline or online. And because you have hired these services, any deficiency in that services can actually be taken to the consumer forum. And you know that Consumer Protection Act 2019, as it stands today, can also deal with unfair trade of these tutorials and unfair terms of these coaching institutes as well. Now coming to university, friends, you will notice that university is a formal education, right? And in universities, please note, you go in for some kind of an academic rigor. There is an academic curriculum, there are academic bodies. And hence, you cannot say that anything that is academic, for example, it could be classroom teaching, it could be something of, the qualification of the teachers, it could be about examination, it could be about grading and so on and so forth. These are all academic matters. Now, interestingly, friends, many of these academic matters are not bought on hire, right? You are not paying consideration, and that's why the university is not going to promise you a degree. So the academic matters to be brought under contract is a problem because it's not a commercial deal or a commercial understanding. However, if universities are providing administrative services, like it could be hostels, it could be any other administrative services like cafeteria or any other facilities that students can have, I think that kind of administrative services with the student can be a contractual one. Now, for example, if I'm going to a PG or paying guest and I'm taking a room, isn't that a contract? Similarly, if I'm taking a room in the hostels of the university, isn't that also to be equated into a contract? Now, that is where probably we have to make a distinction about the two kinds of services by universities. One being academic, which probably is not contractual, is not bought, it's not on hire. It is based on, say, your performance in the examination and the grading system. It is based on, say, your research project and plagiarism regulation. It is based on your academic and disciplinary matters. So if there is indiscipline, probably there is an action to be taken. And hence, those are not necessarily actions that are contractually in nature or should be governed contractually in nature. Those are aspects that I think we have to remove it and keep it beyond the domain of contract. Whereas anything that is of administrative character and nature, those services can definitely be governed under law of contracts. Right? So I think that is one way in which contract law probably has to be evaluated in a student-university relationship, and hence you will notice that contract law gives advantages, and hence you would probably explicitly say what are the duties and obligations of the parties to a contract, right? And what amounts to termination of this contract, what amounts to damages in this contract, so on and so forth. So contract law in the UK is widely used for university relationship, and because the Indian law is foundationally based on common law, it is based on UK contract law. I think in India, going forward, either we deal this relationship under contract law, or we have to promulgate a special statute under the University Grants Commission or under the Higher Education Council, which will actually talk about the specific grievance redressal mechanism, specific adjudicatory processes through which this kind of relationship can be governed. Now, it is inevitable, friends, that we look at this very, very seriously because of the privatization of education, because of the mushrooming of universities and services that these universities are now actually providing for. Don't forget the fact that many of these universities are making a lot of representations. They're talking of dual degrees, whether recognized or permitted by the UGC or not. They're talking about tie-up with the foreign institutions. They're talking about off-campus placement, and so on and so forth. So there are a lot of promises universities make. Students rely on these promises, and hence I think when the promises go horribly wrong or they are not there, the students must have some kind of grievance settlement, right? Universities ought to be held accountable. I think that is the whole crux of this issue, right? If there is no law that holds them accountable, naturally it will result in exploitations of the students, and that I think is not a good thing for the legal system. And hence, either the regulator, that is the University Grants Commission, or a law that governs this kind of format is, I think, the way forward. Hence, this topic is some kind of an introductory evaluation of topic, because remember, this is a law that is 1872. It's an Indian contract law, 1870. It's an old law, and there are new relationships that are being established. And hence, can we look at the application of this old law to new relationships? Is it good? Is it viable? I think those are some of the interesting facts that we must look at our course, which we title it as Advanced Contract. Now, what is Advanced Contract? It is looking at relationships today and the contract law and its application as well, right? Okay, now I think the conclusion here is quite important. The conclusion is that we have to make a distinction between academic and administrative services. There is no problem in applying contractual relationship for administrative services, but I don't think for academic examination and evaluation and disciplinary conduct, contract law is a suitable law. Friends, I think it's important at this point of time that we understand what and where are the sources of contract law. Where does contract law come from? I think it's very important. Yes, contract law is generally something that we understand from legislation. Right? So the Indian Contract Act 1872 is a law. It is considered to be passed by the legislatures, say post-independence, post by the parliament, or it could be by the state assembly as well. For example, the Consumer Protection Act of 2019. It's a legislative mandate. It's a law. Legislation is always one of the sources of law. However, friends, you will notice that legislation is not only the only source of law. Law can actually come from, say, what we call as judge-made law, right? Because, friends, you will notice that the legislature does lay down the basic law, but, interpretation of that law comes from judges. Please note the application of the law also comes from judges. And hence, you will notice that case law is one of the greatest source of contract law. And we have understood contract law in its application, in its operation, only by reading cases or case law. And hence you will notice that even if you go to the Constitution, and if you read Article 141 and 142 and several other provisions of the Constitution of India, it clearly says that the judges have the power of making law. They can give directions, they can give judgments, they can decide, and what the judges say is also the source of law. Right? So this is something that we call as precedent. Now, precedent is nothing but a law that is binding in terms of understanding of the law. It is something that will be applied in future cases. That is what precedent we say. So a case law is a precedent. It has to be followed subsequently. And we know that there is Supreme Court of India. We know there is High Court. We know that whatever is said by the Supreme Court is the law of the land for the entire country. Whatever is said by the High Court is law that applies to that state, but is also of a lot of value in other states. Because please know, High Courts are also constitutional courts. High Courts can also look at interpretation of law. And hence, we cannot say that the judgment of one High Court has no implication in other states as well. So the High Courts also play a very important role. And contract law is generally understood by these case laws, and what the courts think is how the statute must be read into. So you will also appreciate that in the UK, largely contract law is judgment law. And we call it common law in one sense. Common law is nothing but what the judges have said must be applicable in common situations of the relationship between individuals. Right? Now, in UK, the judges have consistently brought about a lot of principles and doctrines. And you will notice that those principles and doctrines are actually an important part of contract law. For example, we talk about the doctrine of promissory estoppel. right? It is a kind of law that judges in the UK evolved, that judges in India also have now brought about. So you will notice that while we talk about government contracts, the doctrine of promissory estoppel will play a very, very important role. It's an important principle, right? Similarly, friends, we have so many other principles that judges have pronounced. For example, I told you the principle of unjust enrichment, the principle of restitution, and the judges actually apply these principles, read the statute, and that is how they adjudicate matters as well. So it's interesting that how judges have evolved and contributed to contract law through the evolution of principles and doctrines which become an essential part of contract law. Further, you will notice that international law is also one of the sources of contract law. In India, interesting difference, we have not had many international laws that are binding to contract. But there is an international arbitration law to which India is a party to, and those international arbitration principles, and you know arbitration is a critical aspect of contract, right? Further, apart from arbitration, friends, you will notice that there is a UN Convention on International Sale of Goods. Now, India has not ratified this convention, though we have what is known as the Sale of Goods Act of 1930, but you know there is international trade. You know there is a lot of buying and selling, right from crude oil to probably a safety pin, and we know there are agreements such as WTO, the World Trade Organization, and GATT, which govern these trade relationships. So international law also becomes a kind of source of law because some of these international practices and principles are very, very critical and important. So I think what we know as, say, bilateral investment treaty, multilateral trade treaties, I think to a lot extent they contribute to contract law. We have seen how BIT, this is bilateral investment treaty between India and Australia, have contributed to disputes and challenges in India because you are talking of protection of investment and so on and so forth. So somewhere contract law gets influenced by what is happening in the world. I think there is uniformization of law, especially now with arbitration in place. And a lot of times, I think reading international contract law is useful, right? But don't forget, friends, at this point of time, you have to make a distinction between international contract law and comparative contract law. See, international contract law is something that is, say, sponsored by the United Nations. It could be something that two countries actually agree to. It's in the form of a treaty. It is in the form of a convention. It can be in the form of a declaration. But comparative contract law, friends, means that you are trying to understand Indian contract law with UK law or US law or Australian law. That is what we would say comparative. So how's the position in India and what should be the position in Australia? Or what should be the position in Australia and can we incorporate in India? That is what comparative contract law would actually mean, right? Finally, friends, don't forget that custom is also an important source of law generally, and it's also an important source of law in contract law. Now, if one reads Section 1 of the Indian Contract Act 1872, friends, you will understand that the 1872 law says customs and usages can continue to be the source of contract until and unless they're inconsistent with the statute, right? So this is a normal practice, right? So if the custom is inconsistent or directly in contravention of the statute, then to that extent the custom is invalid. Otherwise, most customary practices in usage in contract law can continue. Yes, and to give you an example, there is a customary practice where the captain of a ship who is on a voyage and in high sea comes across, say, a rough weather. And there are chances that the ship, because it is heavily loaded, is going to sink. Now, to balance the ship and to see that it's floating, please note there is a customary right of the captain of the ship to offload certain goods and to save the ship from sinking, to save the men on the ship, to save certain goods on the ship, and he can make random choices about which goods to be offloaded. This is a customary practice, right? Now, please note there are so many such customary practices, say, in a country like India, because we have rich traditions, we have rich society, cultures, and all of these customary practices have a great source for contract law. We will know more about that as we go forward, but at the same time, let me now give you an Indian example on custom as a source of law. Friends, we have always seen that there is something called the law agency, right? Where you are one person who needs one more person to represent you, right? This is what we call I need an agent, right? So there is a relationship of the principal, there is a relationship of an agent, right? I need someone to represent me. For example, I need an advocate, I need a broker, I need a insurance agent. These guys will represent me, they will make the contract for me. That is what agency is all about. But interestingly, friends, if you apply custom, here the real question is, can such agency be there in marriage? Which means, can the wife represent the husband? And can the husband also represent the wife? Now, in certain customary practices, friends, you will notice that actually in certain customary practices, wives do not have representative character. Yeah, they are denied the same. Similarly, husbands also are denied representative character in certain customary practices and in certain societies. So while the general rule says, the spouses can represent each other in commercial transaction, but please note what is the extent of that representation, right? Can the wife go ahead and pledge the property of the husband for anything and everything? Or is it only for necessities of life? We'll have to probably understand that as we go further. However, the wife can definitely go and buy goods on behalf of the husband, right? That is something that we have to allow. And the husband also can deal. But can the husband deal with, say, the stree dhan of the wife? Should he be allowed to give that representative character if that is done? I think most men would have gone and sold the gold and the jewelry that the woman has got at the time of marriage. So, should men be excluded from the representative character as a customary practice? Maybe it is so. So, those are some very interesting examples, friends, while we talk about custom as a source of law, right? So, custom legislation, case law, international law, comparative law, these are places from where we can understand contract law. And to be honest, friends, unless we look at all these sources of contract law, our understanding of law may not be complete. Now, to be honest, these are sources of contract law not only in a normal private contract, they are also sources of contract law in government contracts, right? So, for example, in government contract, can international law play an important role? Yes, of course it can. Because in most cases, you will notice that the party to a bilateral investment treaty is the government, right? And government companies benefit from the BITs, and the government companies are often involved in disputes that arise from these bilateral investment treaties. So it's very interesting to understand these sources and know these sources, because then you will actually read contract law in a comprehensive, holistic, and in an integrated manner. So friends, trying to understand why in India we have a central contract law, or probably one would want to evaluate why we do not have state contract laws. Can state governments also make a law governing contracts? So for this, I think, one will have to understand the constitutional premise of the division of responsibilities between the union government, the state government, and probably the local governments right now. As we speak, we have the 73rd and 74th Amendment that have taken place in 1992 to the Constitution of India, where municipalities and panchayats also have been given certain powers to govern. So you notice, friends, while we talk about what is known as the 7th schedule to the Constitution of India, there are certain subjects that are reserved for the union government, there are subjects that are reserved for the state government, and then there is a list called the Concurrent List. This is also there. Now, subjects that are for the union government alone can legislate upon. It could be foreign affairs, it could be currency, it could be defense. Only the union government can legislate, and that is an exclusive power reserved for the union government or the central government. Then we have powers to the state government, like police and public health. Please note, public health is a state government subject, but interstate public health will be a matter of central government, right? So that is how I think subjects have been divided in the constitution, so that both the governments have actually their governance role. The list 3 is called the concurrent list. Now, these are subjects in which the center and the state both can legislate. However, if the central government makes a legislation, it will then inevitably prevail over state governments, because we are a kind of a union and a federation, and hence the union government is strong, the central government is strong, and a central law will prevail over every state law. And hence you will notice that the Indian Contract Act, friends, is a central law, though it was made by the British, but then it is applicable to the entire territory of India. Originally, as we see, when we adopted the constitution, we gave exception to Jammu and Kashmir. But as we speak today, because of the reorganization of the Jammu and Kashmir Act that is already in place, the Indian contract law now applies to the entire territory of India, including to the state of Jammu and Kashmir, right? And contracts appear in the concurrent list, partnership law appears in the concurrent list, and hence any legislation is something that either the central government can enact and make it applicable to the states as well. So this is just a kind of an important background that one must note. Why should I study central laws on contract? And this probably answers the same. Moving forward, friends, let's get into understanding contracts, and to do that, I think it's very important for us to understand a very, very important statement. The whole premise of understanding the basic principles of contract lies with this statement called, please note, all contracts are agreements, but all agreements are not contracts. I will repeat, all contracts are agreements. Yeah. You have to agree to make a contract. Two people have to come together. They have to sit in a place, traditionally, not today. They have to agree for the same thing in the same sense. We call it the principle of consensus attitude. And once they agree, then we have a contract in place. So an agreement is critical for a contract, right? However, not all agreements are going to be treated as contract. Why? That's, I think, very important, right? The reason is, friends, if an agreement has to be treated as contract, then it has to fulfill certain essential conditions, right? Now, these essential conditions are what we are going to study right now, because it's very important to understand that a contract needs offer and acceptance. Right? There are two parties, one who makes an offer, the other makes an acceptance. Right? That is essential for a contract to come into existence. Second, there must be free consent of the parties. Right? The parties cannot be forced into making an offer or an acceptance. So that is the second essential condition. Third, whenever this offer and acceptance is made, there must be an intention of both the parties to enter into a commercial relationship. And that's why we say there can be agreements in the social context. Right? We call them social contracts or social obligations. They need not be necessarily enforced as contracts. Say an agreement between a husband and wife. It is still an agreement. Two parties meeting at the table, discussing the same thing in the same sense. But because they're in a social relationship, that kind of an agreement between a husband and wife or a father and son is not necessarily a contract. It's an agreement, but not a contract. Right? So, for an agreement to become a contract, the parties must intend to create a legal obligation. Right? That's why we say agreements that are commercial in character and nature are contract. Right? But if they're social in nature, they are just agreements and not contracts. Right? Now, to make an agreement, friends, which is a simple agreement, you don't need to be competent. But if that agreement has to be treated as a contract, you have to be competent to make a contract. That's what the law says. You have to be above 18 years. You have to be of sound mind. Right? It could be the competency of a company as well that we have to test. That's very important. Otherwise, it will be sheerly an agreement, but not a contract. Similarly, if you talk about consideration, now consideration is very essential to contract. Without consideration, no contract. That's what the rule says, right? So you have to support the contract with consideration, and only then agreements can be treated as contract. And finally, agreements which are valid and have a lawful object can only be treated and enforced as contract. And when you say you enforce it as contract, please note you get the rights and remedies in law. You get the protection of the court. So if the other party breaches, then the law protects you. Otherwise, in a simple agreement, I think the parties have to bear their own risk, because the law does not support all kinds of agreements. The law only supports those kinds of agreements that have to be treated or agreed to be contract. So that's why we say, friends, that for an agreement to be treated as a contract or to be agreed or accepted as a valid contract, certain essential conditions of the law have to be complied with. Only then they become contracts as enforceable in law. Otherwise, we just treat them as agreements. And that's why we say that not all agreements are contracts. However, all contracts are agreements, right? Without an agreement, there cannot be a contract, right? And the agreement is the first step of enforceability. You have to agree. And then whatever you agree has to be with the intention. It should be free, you must be competent, there must be consideration, there must be lawful object. Only then such kinds of agreements become contract. But without an agreement, there is no contract in the first place at all. So these premises, friends, were evolved, to be honest, when we had paper contract, when we had oral contracts or implied contract as we call them, 1872. And please note, in implied and oral contracts, I think all of these had to be tested before a judge intervenes in such kinds of agreement. So he would say, unless these are fulfilled, I will not intervene in oral contracts. That's what is the prescription of the law. Follow the law, then I accept it as contract. If I accept it as a contract, I will give you remedies, I will look at enforcement. But if it does not, then probably you have to go back and the courts will not come to your rescue. So I think it's important that when parties create contract, they want it to be treated valid in law. They must fulfill all these essential conditions. If they not fulfill those essential conditions, probably they don't get the protection of the courts of law. Right? Now, you will notice that, while we talk about these principles in oral contract, we are also talking these principles in paper contract, because please note the development from oral contract came to paper contract because we wanted evidence of the agreement. We wanted evidence that the parties were competent, evidence of what the object is, how it is reflected, right? So we developed the paper documentation as evidence of the contract being made by both the parties. And interestingly, friends, we are now moving to electronic contract, right? E-contracts or digital contract, where probably in the traditional sense parties would meet, but right now the parties don't even see face to face, right? Nevertheless, even as we speak in modern forms of contract, these basic principles of contract, unless they are completed, the modern forms of contract also don't get enforced, right? Including something what we call as smart contracts today.